बिस्मिल्लाहिर्रहमानिर्रहीम अस्सलातु वस्सलामु अलैका या रसूलुल्लाह वस्सलामु अलैका या हबीबल्लाह। प्यारे व्यूवर्स, मैं हूं मलिक फैज़ अहमद वर्ल्ड एडवोकेट हाई कोर्ट और आप देख रहे हैं मेरा यूट्यूब चैनल। उम्मीद करता हूं आप तमाम दोस्त सब खैरियत से होंगे। अल्लाह ताला आप तमाम दोस्तों को सेहत के साथ लंबी ज़िंदगी अता फरमाए। मेरी आप तमाम दोस्तों से गुजारिश है कि मेरे चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें ताकि मेरी हर नई आने वाली वीडियो आप तक पहुँच सके। सेक्शन 414A, no appeal from certain summary convictions under the law relating to price control, notwithstanding anything contained in this code or any other law for time being in force. There shall be no appeal by a convicted person in any case tried summarily in which a special magistrate appointed under section 14A passes a sentence of not exceeding 5,000 rupees under the Price Control and Prevention of Profiteering and Hoarding Act 1977 or under any other federal law or provincial law relating to price control. Section 415. Proviso to section 413 and 414, an appeal may be brought against any sentence referred in section 413 or section 414 by which any punishment therein mentioned is combined with any other punishment, but no sentence which would not otherwise be liable to appeal shall be appealable merely on the ground that the person convicted is ordered to find security to keep the peace. Explanation: a sentence of imprisonment in default of payment of fine is not a sentence by which two or more punishment are combined with the meaning of this section. Section 415A, special right of appeal in certain cases. Notwithstanding any contained in this chapter, when more persons than one are convicted in one trial and an appealable judgment or order has been passed in respect of any such person, all or any of persons convicted at such trial shall have a right of appeal. Section 415 Section 416 REP by the Criminal Law Amendment Act 1930. Section 417 Appeal in case of actal. Subject to the provisions of subsection 4, the provincial government may in any case direct the public prosecutor to present an appeal to the High Court from an original or appellate order of actal passed by any court other than a High Court. Number 2. If such an order of actal is passed in any case instituted upon complaint and the High Court on an application made to it by the complainant in this behalf grants special leave to appeal from the order of actal, the complainant may present such appeal to the High Court. 2A. A person aggrieved by the order of actal passed by any court other than a High Court may within 30 days life an appeal against such order. Number 3. No application under subsection 2 for the grant of special leave to appeal from an order of actal shall be entertained by the High Court after the expiry of 60 days from the date of that order. Number 4. If any case the application under subsection 2 for the grant of special leave to appeal from an order of actal is refused on appeal from that order of actal shall lie under subsection 1. Section 418. Appeal on what matters admissible. An appeal may lie on a matter of facts as well as matter of law. Explanation: the alleged severity of a sentence shall, for the purposes of this section, be deemed to be a matter of law. Section 419. Petition of appeal. Every appeal shall be made in the form of a petition in writing, presented by the appellate or his pleader, and every such petition shall, unless the court to which it is presented otherwise direct, be accompanied by a copy of the judgment or order appeal against. Section 420. Procedure when appellate in jail. If the appellate is in jail, he may present his petition of appeal and the copies accompanying the same to the officer in charge of the jail, who shall thereupon forward such petition and copies to the proper appellate court. Section 421. Summary admissible of appeal. On receiving the petition and copy under Section 419 or Section 420, the appellate court shall pursue the same, and if it considers that it is no sufficient ground for interfering, it may dismiss the appeal similarly, provided that no appeal presented under Section 419 shall be dismissed unless the appellate or his pleader has had a reasonable opportunity of being heard in support of the same. Number 2. Before dismissing an appeal under this section, the court may call for the record of case, but shall not be bound to do so. Section 422. Notice of appeal. If the appeal court does not dismiss the appeal, similarly, it shall cause notice to be given to the appellate or his pleader, and so such officer as the provincial government may appoint in this behalf of the time and place at which such appeal will be heard, and shall, on the application of such officer, furnish him with a copy of the ground of appeal. And in cases of appeal under Section 411A subsection 2 or Section 417, the appellate court shall cause a like notice to be given to the accused. Section 423. Powers of appellate court in disposing of appeal. Number 1. The appellate court shall then send for the record of the case, if such record is not already in court. After pursuing such record and heard the appellate or his pleader, if he appears, and the public prosecutor, if he appears, and in case of appeal under Section 411A subsection 2 or Section 417, the accused, if he appears, the court may, if it considers that there is no sufficient ground for interfering, dismiss the appeal, or may. A. In an appeal from an order of actal, reverse such order and direct that further inquiry be made, or that the accused be retired or sent for trial to the Court of Session or the High Court, as the case may be, or find him guilty and pass sentence on him according to law. B. In an appeal from a conviction, reverse number 1, the reverse the finding and sentence and acquit or discharge the accused, or order him to be retired by a court of competent jurisdiction subordinate to such appellate court are sent for trial or to alter the finding, maintaining the sentence, or without altering the finding, reduce the sentence, or three, with or without such reduction, and with or without altering the finding, alter the nature of the sentence, but subject to the provisions of section 106 subsection 18 do 3, not so as to enhance the same. C. In an appeal from any other order, alter or reverse such order. D. Make any amendment or any consequential or incidental dental order that may be just or proper. Number 2. Omitted by law reforms ordinance 1972 items 147 CRPC. आखिर में मैं तमाम दोस्तों का शुक्रिया अदा करना चाहता हूँ जिन्होंने मेरी वीडियो को पूरा देखा, और जो दोस्त मेरी इस वीडियो पर नए आए हैं उनका मैं शुक्रिया अदा करता हूँ, और गुजारिश करता हूँ कि मेरे इस चैनल को, अगर वीडियो अच्छी लगी है तो मेरे इस चैनल को सब्सक्राइब कर लें, घंटी और लाइक के बटन को दबा दें। कल तक के लिए मुझे इजाज़त दें। इजाज़त लेने से पहले मैं आप तमाम दोस्तों का एक बार फिर शुक्रिया अदा करना चाहता हूँ। अल्लाह हाफिज़।